Ran kala panel discussion on appoint pipondo autonomous state pen 6 schedule ko puthak se elitum discussion po mate chingwai pon po lapen labang so discussion long ke debate takali sita what is black and what is white aki kupima akelo kupima lapen constitution lo kupima kido lasote pensi sethan bonji nasik chuningri lo kibang Ladak ke bang aporte lapen injil ke thege ding dum maram dame nale dum discipline pen maintenance on the message ku ladak ili tum jasemet he potak se tham mon japot nongri long pat aparman se tum ka japon pot ladak kumane laposon thur ham pen lamgang tang pen laposon langnodak pen laposon behavior mang ili tum claim confederation te message pusi nilihin president kami nale tomban tuning report mo dahil la first session tampon fit po karjupon kang tulo bang dalahan lo 6 schedule puli tom chethan piglo ong do batoma mangke 6 schedule ke chodor de potan injilo 6 schedule B on opposite autonomous state in Anjibu. Some sections of the people says that 6 schedule is too small. So implementation of Article 244 is must for Karbi Anglong and Dima Hasao. Lasila bangso alam he nelia prangsi pini kacopa pondo elitum panelist lo itom that resource person akya isa Elvin Teron chief advisor to the CM Karbi Anglong Autonomous Council alangli pangsinili aprangsi apor pikompo atima alangli Halloween kitang tuji pusi datang pale kasi alangli pangsi apor phalang nepin pen neli aprangsi alangli pangsi apor pikompo
So, good morning to everybody. My honorable panelists and friends who have gathered here. I'm glad to be able to begin the discussion today and set a tone perhaps of the discussion. And the question raised to me was, why is 6 schedule so inadequate that we have to resort to demanding for Article 244? That is the question presented to me. I normally don't refer to books as often as necessary, but today I have decided to use this book because this book is familiar to people of Karbi Anglong. And most of what I speak, what I say, can be cross-checked from this book. Now, at the beginning there is a controversy about whether 6 schedule is separate from other parts of the Constitution. And the greatest proponent of that idea happened to be Justice Hidayatullah, who in his defense, in his dissenting note in the Barre case, Edmondson Barre case versus the government of Assam, very at length defended the right of the tribal people to self-determine themselves, and he called it a miniature constitution, and 6 schedule need not be referred to other parts of the constitution. That's the first thing. But when we go, which Justice B.L. Hansaria disagreed. He contested this contention, and eventually you can refer in this book, particularly in page 155 to 158, you can refer in this book, which says that my stand has been supported by the Constitution Bench of the Supreme Court. Now, what is a schedule? The Merriam-Webster Online Dictionary says a schedule is a list or statement of supplementary details appended to another document. The legal definition of Merriam-Webster and Oxford Dictionary of Law do not differ too much. Oxford Dictionary of Law says a schedule is an appendix to an act of parliament or other legislation that deals with points of detailed supplementary. And these points, why this is so, Justice Hansaria explained it in page number 156 of this book. And I read from him. The provision of the sixth schedule cannot be interpreted by forgetting the texture on which the Constitution has been woven. The sixth schedule cannot be completely insulated from the rest of the Constitution, and it is as much part of the Constitution as in any other schedule or provision. So he doesn't make any difference between schedules and other provisions. They are all the same in the Constitution. The sixth schedule has not provided by itself the complete constitutional arrangement for the governance of the territories in question. In so many matters, to wit, citizenship, fundamental rights, elections, union legislature, financial relationship, the tribal areas are interlocked with the rest of the country and the rest of the Constitution. So complete segregation of schedule is not possible to visualize. This is a statement of the author of this book, B.L. Hansaria. So the truth is that some people may try to please us by saying that you are independent, sixth schedule is very powerful, and it is separate from the rest of the Constitution. It is a mini Constitution, and therefore we draw our strength from there. We draw our strength from there and try to find ways how to protect our people. That is the contention. Now, Justice Hansaria, in his so many interpretations of this, he also said that we have to look into the lacunae of the sixth schedule in order to interpret it properly. And that's why he went at length to go about explaining para by para in this book. And when you read this para by para, then you will find the lacunae and so on. And then he has referred to many cases, and even in all the cases, we find the judicial review, and we know the contention and the conclusion made in the interpretation by the courts of the country. So this is one thing I want to say. Second thing, what I want to speak is about the word autonomous. In point number 5 of the analysis, in page 155, if you see in this book, he referred to Hidayatullah who said that the word autonomous, signifying the possession of the right of self-government, was regarded as the keynote of the sixth schedule provision. So this is what Hidayatullah said. And in this, we understand that